Be ready and start. In the instant batch of appeals, one fact is common that the orders were placed for various nature of construction works for its execution, and the agreement executed between the parties includes a separate chapter for settlement of disputes, leaving any dispute of difference between the parties to be resolved through the process of arbitration by appointing an arbitrator invoking clause 64 within bracket 3 of the contract stop. As per terms of the agreement, date of completion of the project was delayed as alleged due to breach of obligations by the appellants, and the scheduled date of completion had to be extended. Stop. Meanwhile, due to rise in the prices of raw material, the project was impossible to be completed by the respondent contractors, and hence correspondence was made to either pay the escalated price, or in the absence the respondents would not be in a position to conclude the contract. Stop. It was alleged that the appellants accepted the terms and conditions for escalated prices and asked the respondents to complete the work and hand over the project. Stop. Next stanza. But when the respondents raised the final bills in the predetermined format within bracket, which also included the no due certificate bracket clause on the newly agreed prices, dispute has arisen in content of payment of escalated prices or withholding the security deposits, taking note of the existence of arbitration clause in the agreement. The respondents sent a notice to appoint an arbitrator as per clause 64 within bracket 3 of GCC to resolve the dispute of payment of outstanding dues, which was declined by the appellants by sending the reply that no due certificate was signed and that entails no dispute to be sent to arbitration. Stop. Since the appellants failed to appoint the arbitrator in accordance with the arbitration clause in the agreement, each of the respondent filed application under section 11 within bracket C of the Act before the High Court for appointment of an independent arbitrator, and the primary objection of the appellants before the High Court was that on furnishing the no claim certificate by the contractor, no dispute subsists which is to be sent to the arbitrator, and further the claims which has been submitted were beyond time as prescribed in the agreement, as thus falls under the accepted matter in the agreement. Stop. Next stanza. After the matter being heard, the application for appointment of arbitrator under section 11 within bracket 6 of the Act 1996 came to be decided by the High Court of Rajasthan by separate orders within bracket S, keeping in view the independence of neutrality of arbitrator as envisaged under section 12 within bracket 5 of the Amendment Act 2015. Stop. अगर आपको कोई भी वर्ड डिफ़िकल्ट लगे उसकी आउटलाइन के लिए या किसी भी तरह की कन्फ्यूज़न के लिए आप नीचे कमेंट करें। थैंक यू।